defendant or to commit a felony in any dwelling house. All right, so that's this last sentence here is about in the home, doesn't apply. We're in the movie here. Okay. So was it necessary while resisting an attempt to commit a felony? All right, so let's talk about that. And that's why I'm talking to you about necessary. Okay. We're going to talk about this in just a second. I just want you to keep that in mind. Okay. Is it necessary? That's justifiable homicide.
Guys, I'll get to the
Then you
super
learn
chats
about
between the
excusable homicide.
two arguments.
Now, here's excusable homicide. Everybody see that?
Just let you know I see them.
The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. Now, the reason that when I started my cross-examination with the defendant, I asked is, was this an accidental shooting or did you intentionally shoot him? You know, you might, well, why would we ask that question? This is exactly why. Just to cover. Okay? This is not an accidental shooting. This is an intentional shooting. It's just that he's saying he intentionally shot him and it was lawful self-defense. Everyone understand what I'm saying? This is not an accidental shooting. It's an intentional shooting. He's just saying he had a defense.
Theodore Edgecombe to the courtesy phone, please.
Wasn't very practical. All right, everyone understand that. That's what this means. When the killing is committed by accident and misfortune in doing a lawful act. So let's say someone's cleaning their gun and the safety's off and the table leg breaks and the gun falls and someone dies because the gun went off. That is an accident.
Why are we talking about stuff that does not apply?
The defendant intentionally shot Chad Olson, so none of these apply. By law, though, you might say, well, why are we hearing about these then? Because the law requires that you hear this. That's why you're hearing it. The law requires it.
The law doesn't require you to talk about it on closing.
Number two. Number three, committed by accident, and it talks about a dangerous weapon not being used, okay? Accident, accident, accident. This whole instruction doesn't apply.
Can we talk about it another 20 minutes?
Number three talks about a dangerous weapon, okay? And then there's a definition. A firearm is a dangerous weapon. So the whole excusable homicide doesn't apply to this case. Again, the law requires you hear it. That's why I'm telling you about it. So what's the crime of murder in the second degree? So here, remember we were talking about at the beginning of closing arguments that crimes are built of elements. And when you go to school, the way people explain it are their building blocks. And we have to prove each of these elements to you for the crime. The way it works is this. There's a highest crime that's charged. The highest crime that we've charged in this case is called murder in the second degree or second degree murder. Again, it's interchangeable. If and only if you feel we have not proven that crime beyond a reasonable doubt, you go to the next one that we're going to talk about, which is right here, manslaughter. Okay?
I bet he spends more time talking about manslaughter than second degree.
This is the main crime that's charged. When you deliberate, you start with this one. You take all the credible evidence.
But after you immediately discard second degree murder, we want you to take a look at this one.
Chad Olson is dead. Obviously, we have that. So we know that element's satisfied. Okay? So that's how you analyze a case as a juror. So let's talk about what second degree murder is. Element number one, do we prove that? Yes. Element number two and element number three go together, and that's basically what the defense is in this case. Element number two, the death was caused by the criminal act of Curtis Reeves. Number three, there was an unlawful killing of Chad Olson by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. Then there's definitions. An act is imminently dangerous to another and demonstrating a depraved mind if it's an act or series of acts, and then there's more things. So you take all the credible facts and you apply them to the elements. Would a person of ordinary judgment, would that person know it's reasonably certain was the act reasonably certain to kill or do serious bodily injury? Okay, if you shoot someone basically in the chest, obviously a person of ordinary judgment would know that act would kill somebody or seriously injure them. Number two, we're going to say for a minute.
Interestingly,
Number
that's not
three,
in evidence, but
the act, which is the shooting, right? That's the act. Okay.
it could have
So
had
the
an expert
shooting,
testify to that.
The person with ordinary judgment, no shooting person in the chest can result in death. Yes, That's number one. Number three, is shooting someone in the chest a nature, is that an act that itself indicates indifference in human life? Absolutely. If you shoot someone with a firearm in the chest, obviously it's an act.
This is a terrible close.
The one that we need to discuss is that this act, the act of shooting, was the defendant shooting Chad Olson, an act done from ill will, hatred, spite, or evil intent. Now that's the issue for second-degree murder. So in order to determine whether or not when he shot him, he was acting from a place of ill will, hatred,
Should be
spite, or
interesting.
evil intent, that's when you go back to the totality of circumstances that we had just been discussing.
Now they want to talk about the
In a
totality of the
very
circumstances.
summarized fashion, it's the cell phone light bothering him. That's the beginning. The interaction, the instigation to have that cell phone turned off. When it's not, to get up to go tell the manager, to come back and reinitiate the contact. That's all evidence.
Oh, he said
of
contact
ill will,
again.
hatred, spite, or evil intent. And when he
Somebody
takes
writes that the
firearm
long
out, he
crime
puts it
chat is
inside.
orgasming
Why
to
is that
this
so?
close.
Oh, I'm sure they
Absolutely,
are.
That's exactly what happened. And when that popcorn went on him, he lunges. Again, you have to watch that video because it's very powerful to see. It's like
Powerful
he's
video.
saying, and that action in and of itself, when you look at everything, was done from ill will, hatred, spite, or evil intent. Coupled with the statement, however it was worded from the witnesses, the impact of it is throw popcorn at me.
Yeah,
Throw
the
popcorn at
only
me.
real risk here is that the defense will do a close like they did their open.
To throw popcorn at me.
That would
And he
be bad.
lunges forward and he kills Chad
That would be
Olson.
terrible. Hopefully they nail it on
All
close.
those acts show you that when he shot Chad Olson,
Madison,
that he
yeah,
did
they
it
have about an hour and a half
with ill
each.
will, hatred, spite, or evil intent. And I submit to you, it does. He started it, he ended it, and it was a man that was killed over a popcorn toss. Now, if you do not feel that we have proven the case beyond a
Yeah,
reasonable
now he's going to
doubt
get to manslaughter because
for
he
murder
has
in the
no
second
confidence
degree,
in
then
murder too.
and only then do you get to manslaughter. Now, one other thing that I want to bring up about second-degree murder. On the verdict form, you're going to see what are called interrogatories. So on the verdict form, there's questions after the crime. So let's say that you believe, and I submit to you, we've proven that case beyond a reasonable doubt. You would check off that the defendant is guilty of murder in the second degree.
What they should be doing here is not showing the instructions. They should be using the forms.
And it will say,
Use the forms and
did the
actually
defendant-
check the boxes.
Did the defendant possess a firearm? The next one would say something to the effect of, did the defendant possess and discharge a firearm?
Cigar,
And then the
yes,
third
there's a
one would say,
rebuttal.
did the defendant possess, discharge, and cause great bodily harm or death?
It's probably going to be done by
Obviously,
Martin,
that's what
too.
this case is about, and you would check the third question. By law, you have to have all these things done. That's why I'm telling you about that. All right, so if you feel as though, and I submit we have proven that case beyond a reasonable doubt, but if you feel as though we haven't, the next crime is called a lesser crime. It's called manslaughter. This is
Please give us a compromise verdict. Please.
element number one. Chad Olson is dead. Obviously, that's been proven. Then you could do 2A or 2B.
As he burst
First,
through the
is
courtroom,
intentionally
still
committing
alive.
an act. Did he intentionally shoot Chad Olson? Yes. That caused the death of Chad Olson? Yes. You really don't have to go to 2B. If you go to 2B, you have to read, there's a long instruction. I'm not going to read it to you. You're going to have it in your jury packet, or Judge Barkle's going to read it to you. But really, 1 and 2A is fine. So what's the main difference between murder in the second degree and manslaughter? Whether or not someone acted with ill will.
If Reeves is convicted, it's a mandatory minimum of 50 years.
Only difference. So if you find that the defendant shot and killed Chad Olson, but it just wasn't
He'll be dead
legally
within
justified,
5.
it was not
For sure.
a lawful shoot, it was a bad shoot, that would be the crime of manslaughter. Murder in the second degree is it based on the totality of circumstances, ill will, hatred, spite, or evil intent. So manslaughter is a lesser included crime. If you do not feel as though we've proven second-degree murder beyond a reasonable doubt, there can absolutely be no doubt. I submit there isn't for murder in the second degree, but it's certainly manslaughter. This was not a justified shooting. Absolutely.
Prove it.
90% not a justified
That's your burden. Exactly. Prove it was not
Only
justified.
manslaughter. Under manslaughter, there would be one interrogatory, and it would just say something to the effect of, was a firearm used, or something like that.
Yeah, Rooster, we'll do polls after arguments.
The other crime that the defendant's been charged with is the crime called aggravated battery. Okay, and again, you're going to hear all these instructions. Aggravated battery is basically this: that the defendant intentionally touched or struck Nicole Olson against her will. Okay, and it sounds silly, but this, you have to bear with me for the explanation. He shot her, so obviously he intentionally touched or struck her against her will. You don't have to use your own body if a shooting counts. Because
Actually, you have to explain the doctrine of transferred intent right now, because he didn't intentionally shoot her.
In committing the battery, did he intentionally and knowingly cause great bodily harm to her? Permanent disfigurement or permanent disability? Well, her fingers basically shot off. You saw the photographs. Or, number one, did he intentionally touch or strike her against her will? Yes. Number two, in committing the battery, did he use a deadly weapon? That's probably maybe the easier way. Yes, he used a firearm. Okay, a weapon is a deadly weapon if it's used in a way likely to cause death or great bodily harm. That's the definition of it. Obviously a firearm. Okay, so that's aggravated battery for shooting Nicole when she had her hand up. Now, you think, well, how could that be? Well, there's a law called
If it were me, I would have spent about 3 minutes on the criminal charges and
And
focused
here's
my
the law,
entire close on attacking the defense. That's the linchpin of the entire
Basically,
case.
if a person intends to shoot
Obviously,
her,
it's murder and
defendant
aggravated battery if it wasn't
intends
lawful
to shoot
self-defense.
Chad Olson, and in the process shoots a different person, Nicole Olson, the law transfers the intent to shoot the intended person, Chad Olson, to any person who was actually shot. So it sounds kind of circular, but because he intended to shoot Chad and Nicole had her hand up and he shot Nicole, the intent is transferred to her. Now, the caveat to that is if you find that he was acting in self-defense, then it doesn't apply. Okay? That would be the caveat to that. So what's this case really about? Okay? The defendant is claiming that he lawfully acted in self-defense, that there is a justifiable use of deadly force. This instruction is a little bit complicated.
The jury can't read that.
Go through it just to explain what it states. An issue in this case is whether Curtis Reeves acted in self-defense. It's a defense to the crimes of both second-degree murder and manslaughter. If the death of Chad Olson resulted from the justified
And aggravated battery.
force, and deadly force, of course, means what happened here: the defendant shooting him with a firearm in the chest. Now that reminds me of something that I need to address. Real quickly, at the very bottom on my board, and you're going to get this instruction, we do not have to prove for second-degree murder that the defendant intended to kill him, just that he intended to shoot him. And the fact that he died is fine. That makes sense, okay?
It's fine. It's fine. Don't worry about it.
We don't have to prove that when he shot him, he meant to kill him. We just have to prove that he shot him and he died. Okay, that's what.
Well, you have to prove he
You
intentionally shot him
second-degree
without
murder, it's not
justification.
necessary for the state to prove the defendant had intent to cause death. Just that he shot him and he killed him. Okay, just a little teeny distinction. All right.
Yeah, intentional murder
Back
is
to
first degree, no matter how quickly the
justifiable use of
intent
deadly force.
manifests.
Again, every word in here is incredibly important. The use of deadly
Incredibly
force is
important.
justified if Curtis Reeves reasonably believed. So remember, in the first instruction, was it necessary to kill Chad Olson? Absolutely not. Here, did Curtis Reeves reasonably believe that the force was necessary? So you kind of paraphrase that. The use of deadly force is justifiable if Curtis Reeves reasonably believed that shooting and killing Chad Olson was necessary to prevent his imminent death or great bodily harm to himself, while resisting an attempt to commit the felony offense of battery on a person 65 years of age.
Oh, they included it.
So that seems like that's like a loaded paragraph. Let's break it down.
Oh my goodness.
Well, if the judge is going to allow that language in, I would hammer the F out of that.
Yeah, me
And we
too.
talked about it. I was cross-examining the defendant about it. Battery is when you intentionally touch.
I'm really surprised.
I mean,
maybe the state couldn't put forth a coherent argument, but it doesn't really seem to apply to me.
Pushes him, trips him,
Throws popcorn at him.
throws soda on him. That's a battery. It's a misdemeanor crime. Now, if someone is over the age of 65,
wait, he wins then.
Only because of the age. That's the only difference.
But then it's a felony.
About this crime.
Then he wins automatically.
So Bob and Joe are walking down the street. Joe is now 66, 69, let's say 71. And Bob pushes Joe or punches Joe.
I would drill this down his throat.
But because he was over 65. That's it.
And this language says
so,
he can shoot him now.
The use of deadly force is justifiable if the defendant reasonably believed that shooting and killing Chad Olson was necessary to prevent imminent.
Escobar, you've got to ram this right down their gullet.
I can't believe they're going to allow that. It's like an outside legal theory.
I mean, they should just dismiss the case.
It should. You've got all the evidence to support it.
Because it's not contested. There was a battery. His age is not contested.
To die. Absolutely not. So shooting and killing Chad Olson wasn't necessary to prevent imminent death or great bodily harm to himself.
If I were the jury hearing this, I'd say, are you shitting me? Why did I have to sit here for 2 weeks?
It doesn't include bruising. It doesn't even include moderate harm.
No, it includes any harm when you're over the age of 65. You just said it.
Harm. Would a reasonably cautious and prudent person in the defendant's position, with all this training about the escalation?
No, we don't think the judge with JNOV. They already rejected the argument at the pretrial hearing, but it should be if you're going to allow the instruction. That's the distinction.
And the hand came across and grabbed that popcorn, that he was about to suffer great bodily harm. No, this is not a justified killing. Absolutely not. Now remember, don't lose fact.
Just saying it doesn't make it so, dude.
That he said, because it's not just a hand coming towards him. He knew popcorn was thrown at him. He knew that bag was grabbed. And when you watch the video, you can see it. The bag, the popcorn, and he shoots, and he lunges forward. And he says, don't throw popcorn at him. He knows it. It's not just a hand coming in. That's so important.
Even so, you just made the case that if he knew the popcorn was thrown at him, he's justified in shooting.
Does not lead a reasonable person to believe they are about to just be beaten to a pulp.
Now I regret not listening to the jury instructions last night.
Simply not.
I wish I'd known that was in there.
And he started it. And this felony offensive battery is...
Attorney Escobar's on his 20th page of notes.
That's it. A person is justified in using deadly force if he reasonably believes that such force is necessary to prevent imminent death. We already talked about that.
Or a forcible felony.
We talked about that. Or the imminent commission of, there should be a Y here, but imminent commission of aggravated battery against himself or another. So let's talk about that. We got to break that one down. Did he have to kill Chad because he felt he was about to die? The answer we've already covered is no. Did he kill Chad because he thought he was about to be beaten to a bloody pulp?
That's not the standard.
Again, don't focus on that. He says the popcorn, he knows about the popcorn. So none of this applies. So let's talk about where the imminent commission, meaning about to happen. That's what it means. Imminent commission of this crime. Was he about to have an aggravated battery committed against him? Okay, so what's the evidence in this case? And you really got to analyze this. The evidence is this. He reaches in and he grabs a popcorn. He brings it back, he throws it. His hand is on his way back. Nicole Olson has her hand coming up. He's killed.
Aggravated batteries tend to involve the use of a weapon.
No.
By the way,
Because
people,
he had
to
already just completed the
lay
act.
out the
In
legal
fact, he wasn't
lingo.
even so far back to start anything because he was shot for throwing the popcorn.
With his
He
hand in a
shot
fist.
because he was about to be attacked. No, the popcorn had already been thrown and that event was over. And you can see it in the video as well. He throws it and as his hand's coming back, that's when he shot and killed.
Start my closing argument with
There's
the
no
prosecutor's trying to
imminent
distract me by giving me so
of
many things to
anything
argue
else.
with, but we're going to stick to the facts.
Now, let's say that the fact pattern was that he throws the popcorn and he stands there for a couple minutes and now he starts to jump over the seat and attack him. That would be a fact pattern that would apply here for this instruction. But in this case,
It's actually
the
in
video
evidence.
shows you that he had thrown the popcorn, his hand was coming back, and that's when he was killed. And it's all about the popcorn. That's why the defendant is not justified in killing Chad Olson. That's what these instructions say. Now let's look at this paragraph because it's extremely important as well. In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used.
By which he was surrounded
at. The time of
at.
the shooting, what were the circumstances? Okay?
Ugh.
I know I'm
I'd expect a better closing from a high school moot court.
that the defendant shot and killed Chad. He had already thrown popcorn on him. His hand was coming back, and he shot him because of the popcorn. That's the circumstances. So at the time he shot him, what was happening? His hand was coming away. And he knew it was about the popcorn. Despite what he says in any of his statements, both of them, that actually contradict each other, that's not believable. Those are the facts. Now, the danger facing Curtis Reeves need not have been actual. Now, I blew this particular part of the instruction up because it's really important as well.
Blew a lot of things, didn't you?
In deciding whether Curtis Reeves was justified in the use of deadly force, you must judge him by the circumstances. That's what we just discussed. The danger facing Curtis Reeves need not have been actual. However, this is what applies. It need not have been actual. However, to justify the use of deadly force. So the danger facing Curtis Reeves need not have been actual, but in order for him to shoot and kill Chad Olson, the appearance of danger must have been so real that a reasonably cautious and prudent person under those circumstances would feel that the only way to avoid what happened was to kill Chad Olson. Okay? Now, what would be an example of this? Because it's not this fact pattern. This fact pattern doesn't even come close. Okay? The appearance of danger must have been so real. Okay? The defendant is sitting in his chair. He's just instigated this person. He reaches over and grabs the popcorn, and now it's coming back. That's the
Instigation is not a legal term.
Okay? There's no imminent.
Well, you can't use provoked.
He had just completed throwing the popcorn. Again, we know it's about the popcorn from the statement. What would be an example of this? Okay?
If it's provoked, they can ask for a
Very
mistrial.
important not to be confused by what this means. Here is an example of how the appearance of danger must be so real that a reasonably cautious and prudent person would think they have to kill another human being. Two people get in a road rage incident. They pull over to the side of the road. Driver one gets out. Driver two gets out. Driver one starts making some threats to driver two. I'm going to kill you, you mother. Yeah, I'm going to kill you. Okay? Now, in this case, there's no threats like that. Now, the defendant wants you to believe there's threats. Remember, not a single person hears any of these threats because it didn't happen.
A single
Driver
person
one
heard
gets out,
the
driver
threats.
two gets out.
Curtis.
Driver one is threatening to kill driver two. Driver one suddenly turns around, runs back to his car, reaches in, grabs his wallet, turns around with this black object. Driver 2 is like, oh my God, this guy just said he's going to kill me. He's turning around with a black object. I'm going to have to kill him. Bam.
Why is the object black? Racist.
The appearance of danger
Could have been a stainless
is so
gun.
real that a reasonably cautious and prudent person under those circumstances would realize that shot had to be taken. That would be a perfect textbook example of what this means. Because he was just threatened. Someone was going to kill him.
A reasonably perceived threat does not require some verbal threat beforehand.
Killed driver number 2. Of course it couldn't. But the appearance of danger was so real. He threatened to kill him. He ran to his car. He grabbed a black object, and he suddenly turned around. Any reasonable person under those circumstances would say, yeah, I can see how that guy was hit, that a gun was just taken out. Obviously, that wallet couldn't kill him, but I would have shot him too. Textbook example of what this phrase means. It does not mean that because Curtis Reeves, in his mind, believed this imaginary attack happened, that he's justified. Because a reasonably cautious and prudent person in his situation, sitting there, having popcorn just dumped on his lap, would not believe you have to take another human being's life at that moment. It even sounds crazy to mention it out loud, but that's the fact pattern in this case. This instruction does not justify killing Chad Olson.
If Matt's going to sit back there and cross his legs, he should have put some reflective tape on his shoes first.
He didn't. I submit to you, he made up a story in the cruiser to cover his tracks, not realizing so many people saw it.
I would have gotten away with it too if it wasn't for this kid prosecutor.
The whole thing. He didn't reasonably believe for a second his life was in danger. And that's why he changed his story.
I guess he's going to get an hour and a half and then another 30 minutes on rebuttal.
Think about this. He went from 1 attack to 2. Because what does he get by changing his testimony to 2 attacks? It's reasonable belief that something's happening.
He never changed his testimony.
The day of the shooting, again, I submit to you this story is not even credible. But he says that he was attacked after the popcorn fell, completely dispelled by every witness and completely dispelled by the video. But during the trial, he changes his story to say, you know what happened? And it's funny because I asked him, you remember, I said, why? How in the world do you get these 2 stories? He's like, I don't know. How do you not know when you kill another human being?
If he would have known, he would have said that he rehearsed and practiced the 2 stories so well and developed his story to have an answer for everything. Remember, the prosecutor's job is to put you in prison forever.
So why does he change his story? Because he has to add an attack. Because he knows that post-mortem statement is so bad for him. So he changes his testimony and he indicates this. He states, no. The popcorn didn't go to the wayside. And I wasn't attacked with him virtually on top of me. Remember he's saying all that? Remember his first statement? So what happens is I'm sitting there and he jumps up and the popcorn falls by the wayside almost immediately. And now he's coming over on top of me. And I'm back in my chair. Well, that's when he was getting the gun in reality. But let's go with his statement. I'm back in my chair leaning back and I got my left hand out. And I'm yelling, no, and whoa. And I'm touching his chest or his shoulders because remember his own words. He's virtually on top of me. He's in my lap. Well, on the stand, he's like, no, I meant leaning. What? The defense attorney is talking about minutia words to witnesses. He's changing from virtually on top of me and in my lap to leaning.
Escobar looks like he's about to beat this guy to death.
How many reports do you think he's written in his life where it's important to be truthful and accurate? Come on. Because he's painting a picture that he had to kill him, not knowing there's a video out there to disprove it. So he says he's got his left arm out and he's touching his chest or his shoulders. And, I got to kill him. I can't believe I didn't shoot my hand because my left hand's out as I'm fighting him off in this life or death struggle. That's truly not happening. And we know that didn't happen for several reasons. One, there's no stippling on his left hand. Everyone that was shot, everyone that was in front of his gun has stippling. Nicole and Chad. How is it that he doesn't have stippling on his left hand? Well, possibly it's the same reason why he doesn't have an injury from a phone.
Well, maybe the reason you're claiming for no stippling on the fingers, the cone was too small.
Person. It's because it didn't happen. But you don't even have to look at that common sense argument. You just have to
don't think about what I just said too hard.
Played it slowly and rocked it back and forth like you can do it in the jury room to show you that what actually happened is as he's shooting out from the hip, when the popcorn hits him, because he's mad, he takes that left hand, you can clearly see it in the video if you watch it, and based on his muscle memory, he slaps it against him so he doesn't shoot his hand. So when he's like, oh my God, I'm so surprised I didn't shoot my hand, watch that video. His left hand goes up, and based on his muscle memory, he immediately brings it to his chest.
Okay.
That's exactly what happened here. He intentionally killed Chad Olson because he was mad.
So his arm went out and then he pulled it back and he just doesn't remember pulling it back. That doesn't mean he didn't put his arm out. I'm very confused by this argument.
He changes the story and what's he say? In court, he says, well, I came back from the manager and he was staring at me. Now, why was that important? Because he wants to be like, I'm the great de-escalator. You know, to calm him down, I wanted to tell him everything's all right. But he didn't tell that to Detective Proctor, because to Detective Proctor, he says, I reinitiated, because that's truly what happened. And on the stand,
the only person using the word reinitiated is you.
Manager, and that's when I was attacked a full 5, 6, 7, 8, whatever the number is, seconds before. So when I saw his hand coming towards me, that's why I realized I had to kill him. But we know for a fact that didn't happen.
Oh.
Number one, why did he change his story? Number two, what's this first attack that happened 8 seconds before? Well, first he says that he's hit with a fist. Then he says it's a fist with a phone in it. And finally on the stand, he threw the phone at me from some distance. Because I demonstrated on the video that he wasn't even in the camera when it happened.
He was in the camera when it happened.
Let's just go to the next illogical thing. How in the world was it that he's able to be hit with a phone and not be injured? How in the world is he hit with a phone and his wife, who's sitting right next to him, doesn't see it happen? How in the world does not a single person in the theater see that happen?
Because it's dark in the theater.
How in the world is it not captured on video?
It is.
How in the world does he get hit with an object so hard that he continues to go forward?
Why didn't his head pop like a balloon?
In karate.
What? Continues to go forward instead of going back. Dude, it's a 1-pound phone.
No human in the world gets hit with a phone that hard and doesn't yell, ow, oh my God, I can't believe this, and go for their head. It never happened. None of it happened.
There's evidence his hands went to his head.
What happened was he killed Chad Olson for no reason other than the fact he was mad. And if you don't believe that's the reason, he unlawfully killed him, and it's manslaughter.
But for the fact that juries are so unpredictable, I'd be feeling pretty good right about now.
Yeah, that's the problem. Legally, this argument's stupid. Practically, will it work on a jury? Absolutely could.
I'll show you 2 pictures.
We can't read the jury's faces. They can. This is a long close. Started at what? At 8? Or Central? 8 Central? Cypher Warrior says, I've been stabbed and didn't go, ow. This guy must be a pussy.
And these pictures tell you the story.
If some in the jury buy this argument, it's fine. Only one person has to buy Curtis Reed's story.
You may see that his left eyelid is red. From all accounts, people testified that he was touching his face afterwards. The detective indicated that he was rubbing his eye.
Like you would if you'd been struck there.
This is Chad Olson's picture. Did this person
Chad Olson rubbed his chest
reasonably
really
believe
hard.
this was necessary? in
Your
this
privilege to shoot in self-defense is not contingent on the injury you've already suffered. It's contingent on the imminent injury you're trying to prevent.
either murder in the second degree?
You don't need to have suffered a scratch before you can shoot someone dead in lawful self-defense.
Here comes the wrap up, or that was the wrap up. Okay.
Was that it?
Yep.
Oh, thank God.
Thank you, Mr. Rosenhauser. Ladies and gentlemen, let's take 15-minute recess and
3 cigarettes
remember my instructions during the break.
smoked simultaneously.
All right, we're in recess for 15 minutes.
Gonna upgrade to 2 cigars at a time.